36 of those minutes was filled with jurors examining the vehicle. I interacted with the jurors in two ways. I reminded them, the first group and then the second group, that they shouldn't talk, and I told them that they should avoid jostling the dowel. I received one question from the first group and one question from the second group. It was the same question, and that was, are we allowed to close the doors? And I told them yes, they could, which is something I told them here in court on the record before we went downstairs. Present down in the Sally Court area for the defense, Mr. McIver and Mr. Harvey. Mr. Harvey told me down there that it was voluntary that Mr. Samuel and Ms. Clark Palmer were not present. There were all sorts of prosecutors down there, but Mr. Rucker was the one with whom I interacted. He was present throughout, and Chief Walkocha, at a minimum, was there from the District Attorney's investigative team. Ms. Weaver was present should we have had a need to take anything down, but I didn't feel like anything that occurred down there required takedown. CSI Trougett was present throughout, and there were a bunch of media folks at a healthy distance. After the first 8 jurors were done examining the vehicle, Mr. Harvey, CSI Trougett, and Mr. Rucker, at a minimum, the 3 of them examined the dowel of the chair to see if it looked like things were in the position they were when we started the whole process, and they told me that it appeared that way. We repeated that at the very end when Juror 108, the last juror, was done, and I got the same signal that things looked to have been unmoved. Mr. McIver was given a chance to look in the vehicle and see how it looked. And I have 2 other things. I will admit defendants 34. I'm holding it in my hand now. It's also known as image 2855, a photo that investigator Trougett took of the inside of the SUV. It's from the passenger side and slightly to the, from a rear-looking perspective. So you see the front of the back of the front seat, and it was one of the photos Mr. Harvey relied on in making his observation that perhaps the seat wasn't as far back as it was at the time of the incident. And it's unclear from the photo, defense 34, as well as the other photos we saw, whether what's not as far back is the angle of recline or the bottom of the seat. You can't tell that from the photo, but Mr. Harvey has made clear that he believes that the base of the seat is in the correct position, correct meaning essentially the same as it was the night of the incident, and so it would be a question of angle of recline. I spent a little time looking at it before the jurors got down there with the aid of a flashlight, and I appreciated Mr. Harvey's perspective. I appreciated CSI Trougett's perspective, and it really is, if anything, smidgen, pick your word, very slight. And I found that if I moved my head an inch to the left, there was an issue, and if I moved it an inch to the right, there wasn't an issue, and I couldn't recreate exactly where the photo was taken. And so I'm going to let Mr. Harvey add anything he wants to add in just a moment, but I found that based on his representation of Mr. Rucker's, the chair was essentially in the same position as it was when Trougett photographed it, which was then recreated for both the defense expert and the state's expert. I had a flashlight with me when I looked at all this. It created some odd glares, especially off the dowel, which was metal or metallic. And so I ultimately elected not to offer to the jurors an opportunity to have additional lighting made available, although there were plenty of flashlights. Logistically, it could have been done. I did not offer it up, and no juror ever expressed to me, or anyone else as far as I could tell, a desire or a need for any additional lighting. I think that's all I've got for the record. Mr. Rucker, anything you want to get on the record in connection with the jury view?
I think the court has covered it all. I want to make sure I heard you right just about one thing, just to make sure, although the times are in the record, I want to make sure your representation is correct. We started at 14, we ended at 40. I think you said 36, but it's...
Oh, it's 26.
26.
Other reason that we're lawyers and not accountants or whatnot. You're right, that would have been a 26-minute window. You heard correctly, and I spoke incorrectly. That's a 26-minute window, a healthy chunk of which, I'm guesstimating now, more than 5 minutes of which was waiting for the transition from group 1 of jurors to group 2 of jurors. So it is a 26-minute window, and I stand corrected. Thank you for flagging that. Mr. Harvey, anything else you want to get on the record concerning the way the jury view occurred?
No, sir, I think you covered everything. I do still insist that the recline of the seat, not the seat's position relative to the back seat or anything else, needed to be that just a small amount. I'm not going to say smidgen again. Didn't say smidgen. And we'll leave it at that per my exhibit.
Sure. Defense 34 is in. Let's talk about how we're going to spend the rest of the day. We're going to give the jurors a little bit more of a lunch break. I know Ms. Weaver's going to need a break, and some folks have been on since the morning began. So we'll do something on that front. What's left on the state side?
Well, Judge, actually, I've had an opportunity to kind of think since we've been out of the courtroom, and actually the state is going to rest. I'm not going to call any more witnesses.
Okay. So we can bring the jury in and tell them they can go home and be back tomorrow morning.
Right.
Okay. Let me see if there's any rebuttal. I need something spoken on the record.
Yeah.
Okay.
My phone, I got some of my phone.
Okay. So then the evidence is closed. We have some work to do still with the jury charge. You have to leave at 5?
Count 5.
And count 5. We need to work on count 5 as well. I need some time with both. And so my thought is we reconvene 3:30 to do that, if that works with everyone's schedule. You have 2 power bars. And we can try to get closure on the charge and have a little more discussion about count 5. So why don't we say 3:30 is when we'll reconvene. Does that work for the state?
Yes.
Defense? Yes. Okay. Then we'll get the jury in here. I will thank them. I'll ask you if you have any other witnesses, you'll rest, and I'll let them know that the evidence is closed and that they should be here at 9 a.m. for closing arguments. Okay? Let's bring them in, please.
Jury's all present and counted for, Your Honor.
Thank you, Deputy Kane. Welcome back, ladies and gentlemen. You starting to thaw out a little bit? Feel your fingers? Good. Mr. Rucker, if you would call your next witness, please.
Your Honor, at this time, the state would rest.
Okay. Mr. Samuel, anything else evidentiarily from the defense?
No, Your Honor.
Okay. Ladies and gentlemen, the evidence in this case is closed. We have reached another one of these break points. As we discussed Friday afternoon and a little bit this morning, we're going to finish for today. Tomorrow morning, we're going to start fresh and clean with closing arguments. They will be lengthy because it's been a long trial, and if we gave everyone a lunch break, because really we haven't had one yet today, so it's been a kind of choppy afternoon so far. we wouldn't fit the closings in before we needed to break today. And it's always better if we can fit it that way, to have the closings as one complete group. One side's view, the other side's view, and then you begin your deliberations after I give you the charge that I have to give you. So, that will leave the rest of the afternoon for the two sides and myself to talk more about the charge that I'm going to give you. And maybe it'll give them a little more time to be ready for their closings for you in the morning, which they certainly deserve, given how long the trial's been. So I need to impress upon you again, and I know I said it on Friday, but it's still the case. Now that you know that the evidence is closed, it's not time to begin deliberations. You're going to be standing together waiting for the shuttle, walking out together and this and that. Don't share your impressions with each other about the case, whatever they may be, because those impressions lack the effort to persuade you by both sides that will occur during closing. They also lack the law that you must apply. It's not until you hear what the elements are that you can even know, has the state been able to prove anything beyond a reasonable doubt. So please don't start talking about it amongst yourselves. And obviously no outside research. You now have the universe of evidence that you're going to get to work through this case to decide if the state has proven any of the charges beyond a reasonable doubt. I'll see you guys at 9 in the morning and get you in here, get these closings going, figure out where the breaks are going to be in the midst of all that, get you the charge, and then you'll have the case. Any logistical questions? Okay. I appreciate your flexibility. That was a little complicated moving folks around, but you made that as easy as it could be. Enjoy the rest of your day, and we'll see you at 9 in the morning, Tuesday.
All rise for the jury. You may be seated.
No problem. Look, that's the one that was promised. All right. Before we break, just for your planning purposes, Mr. Rucker, since you made the request, I'm going to deny the request for the additional hour that you sought in the motion. But I'll let you know that if you are bumping up against the 2-hour mark, I'm not at 2 o'clock going to ring a gong and you have to end mid-sentence. But I will let you and the jury know that you're approaching the 2-hour mark, and round about the 2-hour mark, not before it, but round about it, I'll say you need to wrap up, and you'll need to wrap it up. I want to tell you that as early as possible so you can start deciding where you're going to focus and emphasize and de-emphasize. But I think that asking the jurors to stay dialed into what could potentially be 4 hours of summation is a ambitious request on our part, and that's about as far as we should try to stretch that. So I understand where you're coming from, and you asked for it for all the right reasons, but I'm going to exercise my discretion and say that the best and strongest and most incisive arguments you'll be able to fit in well before the 2 hours run. Anything else from the state that we need to talk about before we break? No? Okay. Anything from the defense?
Not till 3:30 now.
3:30, we'll talk about the jury charge, and we'll talk more about count 5. If you have magic language that you want in the jury charge about the jury view that occurred, you email that around, great. I'm going to do a little research on that. I don't know that there even needs to be one, but I know when it is a non-evidentiary jury view that comes into play more. It may be that what I said to the jurors before we went on down to the parking level is enough, but I'll have that as a question, whether you all want to add something. Okay. 3:30, thank you. All right, welcome back. A couple of housekeeping matters. The indictment will won't have this sticky note on it when it goes back with the jury. It is unnumbered, but the first 4 pages are the cover sheet plus counts 1 through 7. Unnumbered page 5 onward is a lengthy list of witnesses, and then it's all a list of witnesses, and there's a green sheet because it was a related case. My proposal is that what goes out with the jury is simply the first 4 pages of the indictment. Any objection to that from you, Mr. Rucker?
And so we would remove the witness list and the green related transfer sheet.
I would do that, but yes, that's what would happen. So the jury would get the cover sheet, the plea of not guilty, there's Mr. McIver's signature and Mr. Hill's, and I think a couple prosecutors maybe even signed it, and the date. And then they get the counts, but not all this other stuff. Any objection to that?
No.
Mr. Defense Team?
No objection.
No objection. All right. We will do that. It would be great if it hasn't happened already, if before the charge is done, before I finish charging the jury, you all have organized the exhibits such that you know what you think should go back and what should. I don't care if they're in numerical order, what's going back with the jury. They can work through that exercise. But what is often frustrating for jurors is we send them back and say, don't start till you get the exhibits. And this is a case with many hundreds of exhibits. So when we wrap up today, there'll likely be a long break between closings and charge, if not before the closings are all done. It would be great if the 2 teams could confer to figure out what goes back with the jury, what doesn't, and what falls into that third category of what we have to discuss on the record because there's a disagreement. Please don't say that until the completion of the charge, and then I look to you all to say, all right, what issues do we have with the exhibits? And then you say, well, the first issue is we haven't even begun to organize them. And to that end of exhibits, I will hand to Ms. Weaver in just a moment the juror questions that occurred during the evidentiary phase of the trial, and that will become a court's exhibit. They will become a court's exhibit. I'm going to work with, I have my own homework on getting the exhibits organized because there have been a few court exhibits, the stipulations, things like that. I need to make sure they're all numbered and there aren't 2 court's exhibits with the same number. But the handful of jury questions that we received during the course of the trial will be made court's exhibit to be numbered later. And Ms. Weaver, I'm going to hand these to you.
How many were there?
Don't drop them.
298?
I arbitrarily stopped at 150 to start a new stack, and we didn't quite finish the second stack. 290. Not all were asked, but you were here for the process, and they're all being made part of the record. Okay, those were the housekeeping matters I had. We'll talk about jury charge and verdict form. I have a proposed verdict form here. We'll talk about count 5. Anything more administrative in nature from the state before we get going?
No.
Anything from the defense along those lines?
Yes, I have to know about
We definitely should get started. Was that what, I was trying to figure out what the mini podium was. Okay.
Y'all can't probably let up, right?
It did look like a I don't mind if you leave it up there. All right. I should email to you all I was upstairs working on the jury charge. I tweaked it some in light of what Mr. Samuel submitted. I never ended up seeing anything from the state. You all said you were going to send some response to Mr. Samuel's, you invoked Ms. Rudder's name. Well, I don't have anything. Doesn't mean we can't talk about it now, but it was nothing I reviewed over the break because I didn't get it. Let me email to both sides the state of the draft right now, so you can have it electronically, and if you all can print it up, you have the hard copy. If I send it to you, Mr. Samuel, or who, that'll get it there, and who on the state side should I send it to?
This is going to be the entire chart?
Yes, sir. So a lot of it, we talked about any part of it, but a lot of it will have been what we worked through. A lot of it is what we worked through on Friday. You guys want to start with the jury charge?
Well, we've got to print it now.
Oh, okay. Great. Take a few minutes. And I'll put right here, Mr. Hyde, if you don't mind grabbing these, it's one for each side, just a copy of a proposed verdict form.
Mr. Record,
Thank you. Judge, we're going to see a ruling on count 5 when we read this, so we won't have to worry about the ruling on count 5.
We still need to talk about count 5. You will see influencing witnesses still in there, but that doesn't mean that.
And a verdict form.
And I think it is on the verdict form too. Easier to delete than
Yeah.
add.
You got your verdict form for voluntary manslaughter.
Whoops, that would be a typo.
4 times.
Count 1 and count 2.
Yeah, it would, everywhere it would be, because I was borrowing from a old verdict form. So that would be the first change I made. Mr. Rucker, while we're waiting on those hard copies, have you determined yet whether the state will be opening and closing, saving all your time for the end, or TBD? You don't need to tell me till the morning, but if you already knew, then I'll know what to tell the jury.
We'll talk about it this afternoon.
Okay.
I'll let you know first thing.
Thank you.
Yeah. We'll take you home. Just a couple of minutes, Judge. We'll make sure additional copies.
Sure. Sorry, I didn't, because I have to commute, it's harder to bring copies every day. So while we're waiting on charges, we could talk about the verdict form. It's not real complicated. Assuming I don't include voluntary manslaughter on there, I've already made the change, involuntary, in all 4 places, 2 for count 1, 2 for count 2. And assuming count 5 is removed, if count 5 is not before the jury by the time they start deliberating, any objection, changes, edits to the verdict form from the state?
Okay. No.
That's okay, I wasn't sure who was going to be the verdict form square.
Okay. No.
It's good? Okay. Mr. Samuel? It depends.
Yes.
I'm
I'm a lawyer, that's what I'm trying to say. I think
Maybe.
count 4 in particular, I need to see how you instruct a jury, because they need to know what is a qualifying predicate for count 4.
Okay, fair enough.
So when we get there, maybe we should do this, do whatever you want. I can't tell you definitively whether the verdict form is sufficient if for some reason the jury charge doesn't give them an appropriate verdict. For example, count 4.
Okay.
But let's find them.
Apart from that and the voluntary versus involuntary.
That's
Okay.
the problem.
Okay, not anymore. All right, Mr. Samuel, if we walk slowly through the charge from the beginning, are you in a position to engage?
I'm going to give you the waivers.
Okay. State, Rutgers fleeing the scene. turning to for the state.
Mr. Biden, wait forward.
That's fine. I'll just turn to the state, and Mr. Wakeford or Mr. Abadi are welcome to say, here's what we did about the jury charge. So, let me get it up on the screen again. You will see on page 4, I did add, under defendant's choice not to testify, the 2 words "or discuss" pursuant to our discussion. Page 6 has new language under venue. Assuming count 5 stays in, venue works differently for influencing witnesses. I believe the statute allows for venue to be found in either the county in which the alleged influencing occurred or the county in which the underlying conduct occurred. And it actually matters for count 5 because the only evidence the jury's heard, I believe, is that that conversation happened at Emory University Hospital Clifton campus, which is DeKalb, and the jury has heard repeatedly that the underlying conduct was in Fulton County. So you will see a second paragraph for venue, that normally venue doesn't get a lot of attention, and unless it's one of those cases where the state has had trouble demonstrating venue. But here, we just got that little wrinkle that I think legally it's required to include this piece, and I wouldn't want a juror struggling, hey, everyone said the hospital was in DeKalb. If you had a chance to read that second paragraph, state, it's the yellow one.
No objection from the state.
I think it's accurate.
It's just a question of whether it's in or not.
Yeah, I think it has to be in. I'm not sure underlying conduct is the right phrase, but I think the statute, but it's clearly appropriate. It may be a little wordy, but it looks fine.
Well, let's wordsmith it now. We're not going to have a lot of other opportunities. The phrase from, you are correct, the phrase from 1610-93, it's big and bulky, and I don't mind importing it entirely. I was trying to make it clear, but also be accurate. So you are correct that underlying conduct isn't the 2-word phrase from the statute.
Yeah, and it's supposed to be in which the official proceeding pending or about to be instituted. You know, I think you ought to use the language, because a jury could say it wasn't about to be instituted, it was still 6 months away, and there was nothing. There was no official proceeding, because official proceeding means a judicial proceeding, and it has to be about to be instituted. So why ignore that? Even though it's not obviously going to be the core of our defense, it's an element of the defense that has to be about to be instituted.
What does it? Whether or not pending or about to be instituted. It doesn't have to be pending or about to be instituted. It has to have been a commission or possible commission of a criminal offense. That's the piece that needs to be, that's the underlying conduct I was getting at. And so what I struggled with, what I just worked through, was do I say underlying conduct or do I say where the alleged criminal offense was committed? And I just didn't want it to be circular where they're thinking about, well, wait, we're the influencing witness, or, so I used the catchphrase underlying conduct.
So in this formulation, one of the underlying conduct is the accused murder?
Yes.
Yeah, well, counts 1 through 4. But I can say counts 1 through 4. It's what, correct, it's the shooting. That's the underlying conduct. That's Fulton. the supposed influencing was DeKalb.
Right.
Jurors ought not to get hung up over the fact that that was in DeKalb, because this statute says you could have either or. So Ms. Boston could be pursuing the influencing witnesses count over there, or Mr. Howard could be pursuing it here. So it's not right that I need to engage the jury with, are there proceedings about to be instituted or whatnot. What was Mr. McIver trying to influence this witness about, not talking to the police about? Already it sounds awkward the way I say it, so I think underlying conduct gets to that. But I'm open.
You're right.
Okay.
Throw that back.
Great, we'll leave it as is. I didn't see that, now I'm turning towards, I'm staying with the draft charge that you've got, but we're getting into an area that overlaps with what you shared over the weekend, Mr. Samuel. And I didn't go word for word, but your proposed charge for murder looked a whole lot like what was in there. I did not adopt yours. I said keep what was in the draft.
I didn't change the word.
Well, there you go. We align there.
I
Motive,
did change the motive.
you did.
I added a sentence which I thought was appropriate, and I would like to argue for it.
Let's argue it, because you'll see it's not in the draft. I didn't miss it. Hold on one second. Mr. Wakefield, do you have in front of you what Mr. Samuel sent over the weekend? Someone should get it to you, because there you go. You'll be at a competitive disadvantage. It's just Mr. Samuel talking about that.
Yeah, appreciate it.
So you had an additional sentence about absence of motive may be considered, etc.
And I don't like to say, in addition, if you find there was no motive, or if you can't, whatever, it just is balancing the sentence. You make it sound as if either there's bad evidence or there's not. Well, there could be good evidence, which is the absence of motive. And that's, obviously, that's part of our argument, is that there's, not only did they not show motive, but the absence of motive is what proves there was no crime here. It's circumstantial evidence that it was an accident and not purposeful. Your instruction doesn't give them that particular option. It just says if they have a motive, that can influence your opinion as to his state of mind. It doesn't say, and if there's no motive, it can also negate the state of mind. It affirmatively negates it.
But the state never has to prove motive.
Agreed?
Okay. The charge, pattern charge, I believe is sufficient. It certainly doesn't prohibit your argument. And I'm not going to engage in the way. There's a counterpoint to this neutral charge that never is proof of motive required for a crime. I won't say never, but it's not required to prove murder. If there has been any evidence of motive, you can read what it says. I think that that is sufficient. You certainly aren't precluded from arguing that additional sentence. Felony murder, again, I didn't flashback what you sent. It looked a lot like what I had in there. Did you have any substantive changes?
I did not.
Okay. Aggravated assault with a deadly weapon, I adopted, you added a sentence up front, which needed to be added wherever it was going to go, but up front's fine. It defines assault in the way that is pertinent here, because assault can be defined in a bunch of ways, and it can get real messy for review if the judge gets it wrong, but I agree with the definition of assault you included. It's now the first sentence of the charge for aggravated assault. If we go over to page 9, we get into lesser included offenses. This is all area we need to focus on pretty intently. You can see what I've put in as the transition into lesser included offenses. We can talk about whether that needs to be edited. Mr. Wakeford, your thought about that introduction to lesser included offenses?
I believe it is adequate, Your Honor. State doesn't really have any issues with the court's formulation.
Mr. Samuel?
Well, something better than what we had last week, but that's not saying much. But it's, I wonder if you should say you must or may consider. I'm pondering that a little bit. In the middle of the second line.
I see it. So the parallel phrase from you was you should then decide whether you believe. I'm not wed to either formulation. Well, must in some ways sounds more directive than should. And other than they must acquit if the state has failed to prove beyond a reasonable doubt, there are not a lot of musts out there. So maybe must isn't the right thing to put there.
Correct.
In that case, it should be should, Your Honor, as suggested by the defendants and not may. Because if there's a finding that,
I think should is right, because I think it is appropriate to say there's more to the project than on or off, there's in between. All right, but changing one word, I don't know that salvages it from it's not very good, but at least it's better than it was last week.
Well, that had mitigation.
It did.
Not appropriate. Okay. That was an accident.
I was tugging a little hard on that board. It could have been intentional. That's all right. You okay?
yes, I am.
Good. All right. How about the paragraph for involuntary manslaughter based on reckless conduct? It's largely what I had originally and then that you had in your weekend email. Mr. Samuel, did you have an issue with that?
Well, if that's the definition of reckless I have, then I like it.
Okay. It is, I just don't know if you copied it from me, in which case the one you have is the one I had, which you don't always like, but,
Yeah, no, I thought it was okay.
okay. To wait for any issue with the definition of involuntary based on reckless conduct.
I do not believe so, Your Honor. That's fine. What's on the court's page?
Okay, then at the bottom of 9, going over to 10, is involuntary based on criminal negligence.
This is where the state has a problem, Your Honor.
Okay, tell me what the state's concern is. Now, Mr. Samuel may also have a problem because he had a third recommended paragraph that sort of like well, let me tell you what absence of motive could prove. And it imported some stuff from civil. There's an interesting civil charge about dangerous instrumentalities, and the degree of care varies directly with the dangerousness of the instrumentality. And so if we're getting into civil, maybe we should put all those civil things in there. But let's start with the state's concern, not about Mr. Samuel's proposal, but what is present on the draft.
State starts at a very simple position, Your Honor, which is that this charge cannot and should not be given. Part of the requirement of the involuntary manslaughter statute, I believe it's subsection B, allowing you to be charged in this way. It's a requirement that the defendant or the accused be engaged in lawful conduct with unlawful consequences, essentially. And if I oversimplify, I apologize, but there's a lot of terms of art in here. But that's essentially what it requires. There is no circumstance and no sequence of facts that has been put before the jury in this case that can support the finding that the defendant was acting lawfully when he discharged the weapon.
Well, let's walk through that. There's been no evidence that he shouldn't have a gun, no evidence that he was transporting the gun illegally, that he was unlicensed, that he's a felon, that he's not. So it sounds like it was lawful for him to have the gun, but that's not what you said. You said the discharge of the gun. There's been no evidence that actually firing the gun was lawful.
Your Honor, under OCGA 1611-103, it is a crime, general intent crime, to discharge a firearm within 50 yards of a public highway or on a public highway. It doesn't, and it says without legal justification. So, we look at justification. Justification says that can only be applied in the classic cases of self-defense or defense habitation, etc. None of
Maybe
those.
back on Edgewood, we'd be arguing about justification, but not up on.
Well, even then, that's not what they've argued, but
Agreed.
regardless, under the justification statute, the only way we even conceivably get to a legal justification for firing this weapon while on the road is that, I believe subsection 5 of OCGA 16.320, the justification statute, which states that if the conduct was justified under any of the other laws of the state, the catch-all. The only other law of the state that can possibly count against somebody firing a gun while inside a vehicle on a public highway would be the law of accident at OCGA 16.22.
Which we're charging.
Which we are charging, but the law of accident says that misfortune or accident where it satisfactorily appears that there was no criminal scheme or undertaking or intention or criminal negligence. And the problem we have here is that the court's instruction here says based on criminal negligence in the first sentence.
Right.
So if we're starting from a place where we have criminal negligence in order to even attempt to give this instruction, then criminal negligence removes the justification defense. Without the justification defense, he cannot possibly have discharged the gun in the car legally. Therefore, he could not have been acting lawfully when it was discharged and all of this came to be.
So I just want to play back what you're saying. If it was an accident, it's an accident, and we move on to some other count in the indictment. If it was not an accident, if there was some but the scenario you just described, discharging a firearm on a public highway, Piedmont, that sounds like an intentional act. So let's just say it's New Year's, and he fires a gun on the sidewalk because he's in Piedmont Park and it's midnight. That's right next to Piedmont Park, right next to Piedmont, the street. But he's intending to pull the trigger, and he would say it's not aggravated assault. I wasn't shooting at anyone. So it could be reckless conduct. It could be this discharging a firearm on or near a public highway. But if the set of facts is I didn't intend for the gun to go off, but I was handling the gun in such a negligent way. It's not unlawful for me to have the gun because I've got a concealed carry or whatever you need to have the gun where Mr. McIver had it. But I was sloppy in how I was handling the gun. In fact, I was negligent in how I was handling the gun to the degree where it demonstrated a willful, wanton, or reckless disregard for the safety of the young lady sitting in front of me. That was criminally negligent, but it was perfectly lawful to have the gun, and then it went off and I didn't intend for it.
Well, since the conduct we're charging is not possession of the gun, it's the discharge of the gun and the consequences that ensue, the question of negligence is central. And as Your Honor just walked through it, if we're talking about, I'd like to first start by saying that 1611 and 103 is a general intent crime. It doesn't say that you have to intentionally do it, willfully, wantonly. None of the buzzwords. It just says you can't do it, and that it's criminal to do so unless there are exceptions for shooting ranges and pawn shops and things like that.
So you're saying that if this case were much less tragic and much more simple, and it was simply Mr. McIver, same scenario, and then the gun just goes off in the car, goes through the floorboard, no one's hurt, he either would be not guilty of anything because it was an accident that it went off, or it could be this 1611-103. Whether he meant for the gun to go off or not, he discharged a firearm on or near a public highway. There's not this in-between ground of, well, the way you were handling it was kind of negligent, so...
The statute makes room for that, Your Honor, when it says without justification. The justification statute walks us through some very specific circumstances of what legal justification entails. That's 16.320. And If we're talking about negligence in discharging a firearm, then we are outside the realm of accident as the statutes understand it, and therefore there is no legal justification. So it's either an accident or it's negligence such that he was committing this crime. So either way, the discharge, they can be charged on accident here, but there is no circumstance where the discharge of this weapon was legal or a lawful conduct as considered in the court's charge here. So the jury shouldn't hear this. The jury shouldn't be charged on this because it just doesn't fit.
Okay. Mr. Samuel?
Well, a novel approach, but he acknowledges it's a general intent crime, but then defines it as strict liability. And those are inconsistent positions that the state's taking. If it's general intent, then you have to intend the act. That's what general intent means. It means you don't have to intend to violate the law, you don't have to intend for there to be a certain consequence, but you have to intend the act. Murder is a general intent crime also. So is burglary. I mean, there's lots of general intent crimes. He's then defining it, general intent, as being strict liability. That there's no intent required at all. Either there's justification or you shot a gun in a public place. But that there is the middle ground of you didn't intend to shoot the gun. There was no intent whatsoever to shoot the gun. For example, you could have dropped your gun. Right? That's not a particular defense here, but you could have just simply dropped your gun. And it fell on the floorboard of the car and went off. You wouldn't be guilty of shooting a gun in a public place then, or a public highway at that point.
Well, wouldn't that be accident?
Could be.
Okay.
Could be, but it also could be negligent. A jury could say, leaving out the way in which they would reason through it, what are you doing with a cocked gun with no safety, sitting on your lap when you already have a sleep disorder? They may say that goes so far as to being reckless. They may. We're saying not necessarily because, as you said, having a gun in your lap in the state of Georgia is protected Second Amendment activity. You can have a gun in your lap, cocked, loaded, without safety on it, as long as you're not intentionally pointing it at someone, which of course is totally different matter. And I've cited a number of cases, all of which deal with loaded guns that go off and kill people. And all of my cases
Cite them in what?
the original request for involuntary.
Okay.
It's, you want some quick cites? It's my original submission from last Wednesday or Thursday night when we did our misdemeanor involuntary request.
Is that number 3, the thing that says request to charge 3?
That's
So
exactly.
Chambers and Vick and Nutt.
The Chambers is a distinguishing case, but yes.
Okay.
It's Stewart, Nutt, and Prince.
Prince, Nutt, those are both there. I don't see Stewart, but that doesn't mean it doesn't stand for your
So
proposition.
let me give it to you, 158 Georgia Appeals, 378. All of them involve, now these are not highway cases, understand, but they all involve people whose guns go off, someone gets killed, and the Court of Appeals said it was either reversible error not to charge on subsection B, or it was not error to charge on subsection B if there was some complaint of that. All of them are section B cases.
Let me hand this to you, Ms. Lyon. This has got all the cases, if you wouldn't mind taking a look at some of those cases.
I got copies.
No, she's good. Sir.
I just wanted to say, you got to be careful with Mr. Samuel. I applaud him for jumping on my carelessness here. The phrase general intent was used recklessly by me right there, simply because all I was trying to say is there is not an intent requirement stated in the statute. It doesn't say you have to have done it willfully and with intent to commit a crime or anything like that. What it does say is that you have to have legal justification. Legal justification can include accident. However, where there is criminal negligence, a species of which is reckless conduct, you're not legally justified, and therefore the discharge is an unlawful act. What the statute 1611-103 at subpart B, subsection B says is it shall be unlawful for any person to discharge a firearm without legal justification. There's not any qualifiers there. You just can't do it. So I didn't write the statute, but what it seems like there is that it creates some wiggle room there, but if the facts don't support it, they just don't. And that's what we have here. It was either an accident, which the jury will be charged on, or it was an unlawful act.
So I need to look at some of the cases that Mr. Samuel cited in his submission of defense request to charge 3 and see how they square with, I'm not saying they necessarily invoke, in fact said they don't invoke 1611-103. But I see the language, and it's exactly what it says. It shall be unlawful for any person without legal justification to discharge a firearm on or within 50 yards of a public highway.
Your Honor,
You can.
there are dozens of cases, federal, state, where the legislature omits language of the mens rea, where the courts have said over and over again, and I'm talking about 9-0 in the U.S. Supreme Court, where they say we are not going to assume that the legislature intentionally created a strict liability offense unless it is absolutely clear from the statute, including firearm offenses. Justice Thomas's decision in the, I'll think of the name in a second, but there are many cases where the Congress, and probably federal cases, they just screw up. They leave out the language, shockingly enough. And the courts have routinely said, there are so few strict liability offenses, and they're so unique, FDA, tampering,
Some of the tax ones, but right.
no, the exact opposite. They're actually more mens rea than most. But anyway, without getting into that, the existence of strict liability offenses are so unique that the courts have routinely said, don't ever assume it just because the legislature left out the word knowingly or intentionally. Even willfully would be much stronger than simply general intent. If you need me to cite a bunch of cases before the end of the day, I will on that. But I just quickly looking through 1611-103, there's no case that says it's a strict liability offense. With or without justification. I understand the justification assumes this mens rea and yet a justification. It's not a substitute for mens rea.
So, as I'm following you, scenario A is, it's New Year's, I'm happy, I shoot the gun. It's intentional, there's no justification for doing that, and you're standing next to a public highway, you're in trouble under 11103.
That's right.
If you are walking along a public highway and you feel like your life is being threatened, or someone close to you, and you fire the gun to scare the person off, that would be legal justification if the facts are sufficient.
Correct.
If you are walking along that highway, spinning your gun with your finger in the little trigger guard, because that's a cool thing to do, and it goes off, that could be reckless conduct, it could be criminal negligence, but that's not going to get you in trouble, not to, per your argument, under 11103. Because you're not intentionally firing the gun. It was misfortune, carelessness, recklessness, pick your flavor of non-intent. Am I understanding your argument?
I'm not crazy about their flipping the gun around there. But yeah, there could be instances where your conduct is negligent. And that is just a classic case. You've got a gun sitting on your lap, you know you're sleeping. I can't think of a better case than the facts of this case. So hypothesize. You're sleepy, you have the gun on your lap, you know it's loaded, presumably. It's not pointed at anybody when it's just sitting on your lap, and you fall asleep. Someone could say, you were negligent. That's a negligent thing to do. It's criminal negligence because you could proceed. There could be harm to another person. That's not justification.
Okay.
But it's exactly the definition.
No, you were finishing, and then Mr. Wakeford can have the last word, and I'll take this part under advisement.
Just be with that.
That room's already made in there, Your Honor. In following the argument as laid out by Your Honor that Mr. Samuel is making, misfortune or accident, it is a defense under OCGA 1622. That is a defense under the laws of this state. That is specifically mentioned in the justification statute, which is 16320, subparagraph 5, where it says if you have a defense under the laws of this state, then you can do exactly what Your Honor was saying, lawfully. But that's not what we have here. And that if we're talking about falling asleep, loaded gun, in lap, I mean, we're talking about criminal negligence because it's foreseeable somebody can be hurt in those exact circumstances. And it sounds like it's almost being conceded. Then
They're willing to concede the misdemeanor.
1611-103 makes room for that possibility by including without legal justification. But we're outside of that because the negligence here was criminal. And so there is no legal justification for riding along in a car with a gun out while being criminally negligent. And there's no justification for the discharge of a firearm while being criminally negligent on a public highway. So under 1611-103, no matter how many concessions we make, the facts in this case do not make out a situation where there could have been lawful conduct that could serve as the basis for the charge the court wants to make.
Okay. If criminal negligence, if involuntary manslaughter based on criminal negligence is staying in, do you have an issue with the language of that paragraph? And you should contrast it with the it's 3 paragraphs from Mr. Samuel. I consolidated the first 2, but I did not include the third.
May I have just one moment?
Sure.
Thank you. I guess what's given us pause, Your Honor, with the court's charge is the phrase willful, wanton, or reckless disregard for the safety of others, because that could confuse the jury about whether we're talking about reckless conduct at that point. And I think as we've all found out, it can get very confusing. But I think that's another reason why this charge shouldn't be given, Your Honor, because if we're talking about reckless conduct, or which is a species of criminal negligence, then the shooting here, the discharge of the firearm could have been lawful in the first place.
So we're tabling for now the 1611-103. I agree with you that it's confusing, and I feel bad for the jurors, but if it is appropriate to give an involuntary manslaughter based on criminal negligence charge, I need to define criminal negligence so they know what the heck that is, and that is how it's defined. And there's clearly, the word reckless appears in both reckless conduct and in criminal negligence, and that is confusing, and the jurors aren't going to like it, that they need to pick one if they're going to pick one, if it's not guilty, and they're going to wonder what the heck we're doing to them. But that's not a reason not to give the charge, and that's not a reason to rewrite the definition of criminal negligence. I don't think, I'm open to this because this is what I'm wrestling with the most right now with what's going to be in the charge, is how to help the jurors understand the difference between reckless conduct and criminal negligence, because I shouldn't hold my hands this far apart. It's like a Venn diagram. And there is an intersection, it seems like, definitionally, but they have to be distinct. You're not guilty of both. You can't be. But the words are, in some ways, selected for us. And I didn't tinker with the definition of criminal negligence. All I did was push together, actually just sentences. I pushed together what Mr. Samuel had as his first paragraph, one sentence, with the second paragraph, a second sentence, and that's how I'm charging it. If you find a comparable definition for criminal negligence, I'm happy to think about it, but those are pretty tried and true and time-worn and confusing to jury words that are in there fairly routinely.
Your Honor, would Your Honor be open with maybe if we were able to find a definition for, I guess, reckless disregard, to then include that into, if Your Honor is inclined to give the misdemeanor involuntary manslaughter based on criminal negligence, put that in the charge as well? Maybe that would help clarify. And I don't know if there is a definition for reckless disregard in the law somewhere, but if there is, would that be something that you'd be so inclined to include to maybe help, I guess, make them different and make it not so convoluted?
Well, I'd have to see what that definition is to see if it makes it more or less convoluted, because my concern would be the definition, if there is one floating around out there for reckless disregard, would somehow incorporate even more words from reckless conduct, and then we've created this big circle, and it's...
That already exists.
Yeah.
I understand Your Honor's taking it under advisement. I think this discussion just highlights, however, that if we're in a universe where criminal negligence in discharging a weapon is what we're talking about, then the behavior couldn't be lawful enough to stand to support this instruction.
Okay. Mr. Samuel, your thoughts about the charge on involuntary manslaughter based on criminal negligence?
Well, we'll just consider the fact that we did cite cases, and the ones that we cited were not all civil cases, by any means. There was a footnote to my submission to you yesterday, which cited a bunch of criminal cases that said that the definition of criminal negligence is what I wrote in there.
The willful, wanton, or reckless disregard?
Well,
I'm not quibbling with that. That's the definition I found as well, that I had that same language.
What's the definition of willful and wanton?
imply the element of malice.
Thank you.
Oh, that part.
Well, that's what those cases say.
Okay.
Specifically said.
Not just say, but specifically say.
Well, it's not like, I mean,
No, I appreciate that. I now am remembering the footnote because the word malice.
It's a triple Venn diagram now.
Well, and it's got ink spilled all over it because no jurors hear the word malice and think, oh, that means intent. It's like mentioning Occam's razor. That's Mr. Gardner. But either way, I did read that. I don't intend to include that. I think that the definition of criminal negligence is there, and one of the challenges for both sides is to educate the jury on what they ought to be thinking about in deciding between, if they reach that point, reckless conduct and criminal negligence. But they both involve, one of the reasons why I pulled back from that is that they both involve a lack of intent. Both of those, if you're considering involuntary manslaughter, you have concluded that, it's the point for that prefatory sentence that I added, that Mr. McIver did not intentionally shoot, intentionally kill, didn't mean for that gun to go off. And so you've moved to the realm of it either was completely an accident or there was some recklessness or negligence on his part that resulted in the gun going off. All right. Accident. I think the accident works now, and I put it in a more logical location. The jurors will hear about, start with murder, felony murder, the aggravated assault behind it. Then you get to the lessers, involuntary, reckless, involuntary criminal negligence, and then you get to accident. That seems to flow as the jurors will be learning about what the elements are of counts 1 through 3, if you will. But that language for accident, I think, is pattern / the same as what you had in your proposal.
Other than criminal negligence, which we omitted, of course.
Correct, and I pulled it out of, it needed to be a standalone, and it is now a standalone. It references criminal negligence, but only to make clear that if the jury finds that there was no criminal scheme or intention and no criminal negligence, then they get to the realm of accident. Mr. Wakeford, knowing that I'm mindful of your argument involving 1611-103 and criminal negligence, do you have any issue with the language for accident? It's on page 10.
I think we're okay with this language, Your Honor. I'm a little confused though. The parenthetical here, and no criminal negligence, I'm trying to understand what you and Mr. Samuel were just discussing. So Your Honor will say to the jury, no criminal scheme or intention and no criminal negligence.
Right.
Okay.
I just put it parenthetically that they need to know that as well. It's not accident if you find that someone was criminally negligent.
Yes,
And
sir.
before you were plugged in, I was using a pattern charge for accident that mentioned criminal negligence everywhere, it didn't define it, so I shoved the definition of criminal negligence in the middle of the accident charge about the willful, wanton and all that. And I had not included involuntary based on criminal negligence, and it was hard to follow, to say the least. Mr. Samuel said you need to pull it out, put it up with the involuntary and criminal negligence, and there it is. So you need to, I believe it is proper to reference criminal negligence in the accident charge, because it's not an accident if the jury finds, not that it was intentional, not that the crime of reckless conduct occurred, but it was still criminally negligent to have a loaded gun in your lap, pointed at your wife's back while you were falling asleep. You had an exhausting day in your bedroom.
So, yes, Your Honor, I guess we would move then that criminal negligence definition back into accident if you do not give the other charge, the involuntary based on.
I would need to define criminal negligence there.
Right.
Right.
So, but we have no issue as things stand here with this accident.
Okay. Mr. Samuel, let me know when you have read the proposed charge for count 4, which starts on 10 and goes over to 11, because
I have, and I just think the better way to do it is the second sentence should be murder, felony murder, involuntary manslaughter based on reckless conduct, and aggravated assault are all something like offenses that would support a conviction. So something other than, you might as well tell them one's a felony, one's a misdemeanor, you're not allowed to do that. So you're doing it by just leaving one out and calling the others felonies, and it seems to me you don't have to do it that way. Just tell them what are the qualifying predicates and what aren't. What isn't.
so there are a series of cases. I hear you on that. I understand very clearly why you don't like it that way. There are several cases that have made, I'm just looking for, so there was a case Prather versus State from 03, and then Hughley, Hughley versus State from 2015 that deal with a situation of, there's a murder, at least one of them dealt with a murder, and then a lesser included pops up, and the jury is not told that the lesser included is a felony, because hanging out there is a possession of a firearm during commission of a felony. And whether it is proper, if a jury finds a defendant guilty of that possession of a firearm during commission of a felony, but it's based on a crime for which there has been no instruction that that's a felony. And the way I read those cases, the court says, the higher court says, you need to tell the jury which crimes are felonies if you want to empower the jury to find someone guilty based on possession of a firearm during a felony. You can't guess, and you can't tie it up after the fact.
Well, but
So how would you?
because you just tell them that they qualify, which is the same thing. That way the jury knows they can only do it if it's a qualifying predicate. You know, those cases make sense if someone gets convicted of a felony and that offense, and then the defendant complains, well, how do they know it was a felony? Nobody ever told them.
That's
We are saying, describe it as a qualifying predicate.
Okay.
And that way you're not telling them something that they're not supposed to be told, which is one's a felony and one's a misdemeanor.
But they are
Or at least
supposed.
it's somewhat less obvious.
Okay. Mr. Wade, Mr.
Fuscatory.
State.
It seems, not to use a $10 word, it seems deliberately.
Go ahead, you can.
He said obfuscatory.
Fuscatory.
But I understand the purpose. But this one is tricky for the defense because it's accurate, it's true, it's an element of the crime. in working through this, because I appreciated the defense concern, it's sort of like the defense saying, we'll stipulate he's a convicted felon, so you don't get to tender the certified conviction or something like that. They're not going to be arguing that involuntary based on reckless is not a felony. And I'm not hearing them say, don't even mention it in that count, because that would open up the Hewley and Prather issue should Mr. McIver get convicted of the possession of a firearm and involuntary based on reckless. It wouldn't be just or fair to allow that situation to stand, only to then allow that to be attacked because I didn't make clear to the jury what was going on. I think I'm going to leave it as is, but I wanted to get the state's perspective on that.
I think the court, the language from the Hewley case has said, paraphrase essentially says the jury needs to know what the felony's going. But I think the court's understanding of this issue is adequate. The state has nothing to that.
It is a delicate area, and so I'm now looking at Mr. Rucker. I know he's probably focused on other things. You'll need to be careful in your closing. I don't know if you're doing the whole closing or whoever's going to be talking about the law, you ought not to get anywhere near the fact that there are misdemeanors lurking around out there, or draw some contrast. It is a correct statement of the law that certain of the offenses are felonies and they thus qualify under that statute. But you'll need to be very thoughtful and discreet about how you might ever juxtapose that with any other charge that the jury might be considering. They're going to connect dots that they connect back there where we're not involved, but just need to be thoughtful about that. Influencing witnesses, I didn't add anything to it. I think it accurately describes the statute and elements, and the count 5, pretty simple what's involved because of how direct Mr. McIver was with Ms. Carter. I know, Mr. Salmon, you were hoping for a whole bunch more. Did you have anything less than what you proposed, but more than this, or? Because you have referred several times to him on massaging a new version, but.
No, I didn't decide the version because I didn't know where you were on this, and actually, we shifted our argument a little bit, not to undermine the original arguments, that a variance problem, where, I don't think they're going to be allowed to argue to the jury that the misleading conduct was something other than what's alleged in the indictment, and we will object if they do argue to the jury that the misleading conduct was telling her to lie. I'm sorry, was telling her to, it was okay to lie, because that's not what the allegation is in the indictment.
So let's shift gears to that. I think that's a fair point, and I have spent no small amount of time lining up the indictment and your argument and the statute and my recollection of the various descriptions that have been given of that conversation at the hospital. The point you were just making is important for the state to keep in mind for closing argument. What is alleged in the indictment in count 5 is that the defendant engaged in misleading conduct towards Ms. Carter by instructing her to tell law enforcement officers that she wasn't present, etc. It's not encouraging or threatening or saying it's okay if you do. It's instructing her. That's the language in the indictment. And so it would be improper for the state to argue for some other formulation of that. I continue to believe that the evidence that's been presented to the jury is sufficient to withstand a motion for a directed verdict, in that the jury could conclude from all of the evidence that flows into how Mr. McIver and Ms. Carter are connected in their relationship. I don't mean anything sinister about that, but just the nature of their relationship and what was said and where it was said and when it was said in conjunction with the shooting, that a jury, a rational jury, could conclude that by telling Ms. Carter to do that, Mr. McIver was engaging in misleading conduct. I've articulated why I think a jury could find that, and the state is free to argue from that, but Mr. Samuel has correctly pulled me back from, well, look, if the argument is, he said it was okay to tell the police that. One, I don't think the words were quite that way, although, like I said, we've heard several different versions of exactly how that went down. But two, the state didn't charge that he authorized her or anything like that. He instructed her to do that. But I think that the jury has heard sufficient evidence to allow the state to argue that that mere instruction was something that would qualify under the statute. So it's staying in, but I didn't mean to, and I don't want the state to take from anything I said to constructively amend the indictment. Those words were etched onto the indictment, and they stay there, and nothing has changed them. So, that being said, I don't think we need to add a whole lot, if anything, to the charge on influencing witnesses. But if you have language that you think would further explicate it, that doesn't get into this, who is George W. Bush's defense secretary? Rumsfeld. You got to know what your opponent doesn't know, so you know they don't know that you know. I mean, it got real confusing to us non-logisticians, and so there were reasons why I didn't adopt your proposal. But I'm happy to add more if you have language that doesn't get so Rumsfeldian.
I don't know what you liked and what you didn't like. You can feel free to pick and choose from my instruction, but I thought there was a lot in there that it explains, because if you read the indictment, they're going to say that's exactly what he did. But we all know that what he did is not a crime, as alleged in the indictment, without adding to it the fact that somehow it was misleading. So we're going to have to argue the indictment doesn't allege an offense, right? Those facts, telling someone to lie, does not allege an offense. And they're going to get really confused then.
So you have adopted wholeheartedly King and said, see, it's just not a crime to tell someone to lie. But I've looked at King, and I think there is structurally a difference between saying, hey, it would be great if you and I were in on this together, and so you'll protect me, maybe there's a financial benefit, so please lie to them. You and I both know you'd be lying to them. I didn't read that as instructive, and that's why I keep coming back to there's a different relationship between the parties in King and Mr. McIver and Ms. Carter, such that an instruction is, plus it's an instruction as opposed to an entreaty. I read King as an entreaty, not a directive.
Well, that to me makes it even less, because the statute deals with coercion and intimidation and things like that. And it would have to be alleged that you were intimidating or coercing or doing something to the witness. Again, the witness is the victim in 16-1093 case initially.
Sure.
You don't want to do the whole argument again, I know, but so I want the record clear that we are, and we did it last week, demurring to this count. We do not believe it alleges a crime at all. And when you add the facts of the case, we think there's insufficient evidence to sustain the conviction. So we have both the directed verdict and the general murder count. Can I mention one thing a little off topic? We are filing what I sent to you on Saturday, otherwise it's not going to be correct.
Sure.
The email, I assume you leave in your computer, but we just filed it, so it's in the record.
Great.
Word for word, we didn't change it.
Okay. Okay, I hear you, and I continue to find that an employer, lawyer, source of financial support, et cetera, saying, here's your instruction. I'm not saying it's cool, I'm not making an argument one way or the other, but I can see an argument that doesn't say coerce, because you're right, that's a different allegation, that's not what's alleged.
Right.
That there are facts and circumstances surrounding that exchange, if properly articulated, would support the jury considering that. So I'm going to leave it as is. You have made an uber thorough record as to why it shouldn't get to the jury, why maybe it shouldn't have gotten to paper, but we'll move forward with that. The rest of the charge, I didn't add anything, and it was language that had not raised concerns before. The only other piece I flagged before we broke was jury view, but Ms. Lyne looked, and I concurred with her examination. There really aren't charges for jury views, and if there was going to be anything, I could either repeat what I said, that this evidence should be treated no differently than any other evidence and should be viewed in connection with all the evidence. But issues more typically arise with a scene view where some litigant is saying, Judge, you need to tell the jury that that wasn't evidence. Shouldn't have why they got to go to the scene, but that's not what we've got here. So I did not include anything about the jury evidence view that occurred this afternoon. Mr. Wakeford, did you have anything else? I need to noodle your 11103 concern. And I received good info from both sides on that. Did you have anything else that you want to talk about concerning the charge?
Unless somebody on this end of the table throws something in my head right now, Your Honor, I believe that we do not have anything else to bring to the court's attention at this time.
He didn't throw anything, but he's got something. Mr. Abate.
I want to get charged with battery, aggravated assault, depending on what I throw at him. But the first charge, the indictment, where it says during the commission of a felony and then 3 counts of influencing witnesses, are we at that point? Is that when you'll be instructing them that 2 of the counts of influencing witnesses will be taken out of their purview, or are we going to change that to 1?
So it's a good question. I need to tell the jury before closing so that you guys don't look like, neither side looks like you missed 2 counts in the indictment. I need to tell them tomorrow morning that I've withdrawn from their consideration counts 6 and 7. It is a true statement that the grand jury indicted the defendant for all those counts. But I didn't leave that in there because it's a true statement. I forgot that already 2 of the counts of influencing witnesses are gone. And so maybe I ought to add something in there at that point to say, but of course, only 1 of those remains for your consideration. I don't want them to be confused. They'll become much less confused when they look at the verdict form. There won't be a count 6 or a count 7, but I don't mind repeating that. Mr. Samuel, you thought about that?
I think it should be deleted. Are they going to see 6 and 7?
No, are we going to create a redacted indictment?
Why are we telling them 6 and 7 is out of your purview if it's not even going to be there? Just say they indicted them on 1 count of influence.
Well, I read the indictment to them.
Just say something about that. Just say for your consideration is 1 count of influencing and 4 other counts that aren't been described. Look at our notes from the beginning and see what we can.
So, 2 things. Let's just go chronologically. Do you have any objection to me telling the jurors tomorrow morning before closings, you now have only 1 count of influencing witnesses?
I think that's exactly what it should say.
Okay, all right.
And the first sentence should say, during the commission of a felony and 1 count of influencing a witness.
Okay, which is also true. They were 2 other counts, but they're not before them. So I'll just say influencing witnesses. Influencing a witness.
Correct.
Good catch, Mr. Butler.
You all present.
I caught it too.
Ms. Griffin. You just said anything about it.
You didn't ask me.
We had them like, marked after
All right,
the record will reflect.
so the very first sentence of the jury charge is going to be a grand jury has indicted defendant for ... comma, and influencing a witness. Full stop. So there were three parts to this. I will tell the jury tomorrow morning when one count of influencing witness is still before you. The jury charge is now going to say what we just talked about. The indictment has in it count 6 and 7. We're not touching this indictment. Is the state proposing coming up with a new version that doesn't have 6 and 7 on there, and then we staple this cover? We can't modify this cover sheet that has the plea of not guilty on it. So,
You want to redact the indictment?
We can do a redacted indictment.
I know you can't, is that what you were asking for, or you just want the jury charge to be clear so that they're not worrying about 6 and 7?
That we were trying to anticipate an objection from Mr. Samuel based on some of the conversations we had previously. We're not opposed one way or the other.
What do you think we should do with the indictment?
I think you should write out 6 and 7 from the front page.
That's what we were proposing.
Okay, so you would be willing to have, it would be a photocopy of this page. The bluing page can't go back with the jury then, because I'm not going to do any whiting out on the bluing page. But the state would,
You told them twice in your charge that it's not evidence. Why would you go on?
because I'm sending it out.
I know, but I don't understand. It's not evidence. It shouldn't go on.
Well, the verdict form's not evidence either, but I'm sending a verdict form out. And I send a copy of my charge back. It's just, I'm going to do it. But as long as you don't have an objection, Mr. Samuel, to it being a photocopy of the bluing page, I will ask someone from the state to come up with a redacted version. It's convenient that 6 and 7 are the ones out. Please don't renumber anything. That causes the clerk's office to have bad digestion. And then just have 6 and 7 out. So the only other change is that all the counts will have to say 105, 205. So if you guys could take care of that this afternoon, this evening, and get a preview copy to the defense in the morning, we should be all set.
I'll email them a preview copy this evening.
Okay?
What?
Midnight, 1 in the morning.
It'll be like 7 to hold down. You have to sleep extra night.
All right, getting a little punchy there. Did you have anything else? That was a good catch, Mr. Abate. I've changed it. It's just one count of influencing witnesses, influencing a witness. Anything else from the state?
No.
Okay, Mr. Samuel, I know you had caught that too when you were about to mention it. Anything else? Okay. All right. So first thing tomorrow morning, Mr. Rucker, you'll let us know if you are opening and closing. We'll look at that redacted indictment. I'll get a clean verdict form out that does not say voluntary manslaughter on it. And I'll also let you know if I'm doing something other than leaving the criminal negligence in as it's written. In other words, if I am persuaded by Mr. Wakeford's 1611-103 argument, we'll talk about it. If you don't hear from me on that, then I have pocket vetoed that suggestion. All right, anything else from the state before we break this conference?
Yes, just very quickly, I know we talked about with the court the idea that the state or one of the parties might encourage the jurors that they can request from Your Honor to actually squeeze the trigger of the gun in evidence. Any guidelines around that that you want to make sure the court's comfortable with us?
No, I researched that at the time it came up, and I believe that's appropriate. I think it is appropriate for the jury to do just that. And for the attorney doing the closing, they say, hold your hand, pull the trigger, you can do that. A true statement, legally appropriate statement, I'll work with deputy as to how we make that happen, but that ought not to elicit an objection, and if it does, I'll deal with it shortly. Okay? All right.
And I have just one thing, Judge, just came to my attention, that I just want to bring to everybody's attention. I don't know. May I approach?
Sure. Anything you want to say about it?
I think it kind of flies in the face of the spirit of what the court was trying to accomplish by precluding the media from being able to film or take any photographs. It's a little disconcerting to have a photograph of the inside of the vehicle, there in the garage that the jurors viewed, posted on Twitter by a WSB reporter 2 hours ago or more. And so I just thought I should bring it to the court's attention. I don't know that there's a whole lot of remedy associated with it, but
No, and fortunately, the jurors actually saw just that. And so if there was any concern that jurors might, now the evidence is closed, become a little more lax in trying to stay away from media coverage, this wouldn't show them anything they didn't experience eyeball to eyeball firsthand just a few hours ago. It brings up a whole other issue for a later date as to this WSB reporter resisting a subpoena to say, well, who the heck told you that? But I think that would be the sheriff pursuing that rather than the district attorney's office.
right.
Mr. Hardy, you've been most closely associated with all things excursion. Anything you want to get on the record in connection with this tweet?
Just my disappointment. But I've been disappointed before, and I'm confident I'll be disappointed again. I agree. I don't know whether there's a particular remedy that can be associated with this, and the jurors have in fact seen it. So, no.
Okay. Thank you, Mr. Rucker. Any surprises from the defense?
Always.
All right. Well, I'm sure I will remember to say this later on, but thank you all for weeks and weeks of hard work. I look forward to the closings tomorrow. The more you can anticipate in advance, hey, I think talking about this is going to be the kind of thing that might upset the other side, we can discuss before closings start, because who the closings can go. Like Ms. Convery flagging telling the jurors they can test the trigger on the weapon. But otherwise, we've got a bunch of seasoned professionals, and I'm sure the jury will benefit from both sides' efforts to plead the case to the jury. We'll try to get started as close to 9 as possible. In terms of when we break, as I understand it, the defense is going to split the closing, not necessarily in terms of time, but Mr. Harvey, you're going to cover some topics, and Mr. Samuel's going to cover some. Will you each get in front of the jury only once, or it'll be okay? All right. Well, a natural break point, if folks need a break, and if Mr. Rucker opens and closes, would be after the first of you is done. If you all need a break, that would be the time to ask for it. It might be when I ask the jury if they need a break, not for lunch, but just like a 5-minute break.
If there's no opening by the state, and assuming I go for an hour, take a break after that?
Probably not, because we wouldn't if we had an hour's worth of witness testimony.
That's why I was curious why you just said after the first one you would do it.
Because I would say, assuming Mr. Rucker goes first,
Got it.
because then we could be 2 hours in when you say you're done. But I'm flagging that now because it may be that there's a flaming hot baton you're handing to Mr. Harvey that you don't want to cool off with a break for the jury.
On the contrary, I think we're going to change our PowerPoints. We don't have one, so I think it would make sense to at least take a 5-minute break.
All right, well, I'm glad we talked about it. All right, see you guys at 9 tomorrow. Thank you.